Now we have time for questions, discussions. So I open the microphone, and please, if you have any questions, just raise the hand and the microphone will find you. So can I see? Yes, Professor Postema, please. Microphone, yeah, it's coming, so.
Well, I've had my chance to speak already, so I don't want to say very much, and I want others to join in rather. There is a persisting theme or concern that I'd like to re-emphasize, but address my questions to Professor Roth and the earlier speaker, Torchia, Professor Torchia. It has to do with this idea of contestability. I think it's terribly important in these contexts. It's the core of what I call accountability. And what worries me is that accountability and contestability in the AI system situation look like they're, I don't know what that means. I really don't know what that could mean. I know what investigating the design of algorithms means. And I know how we might not like that design. But the interesting thing about that problem, that task, is that to get close to understanding the design of these algorithms and the like, you must be really expert at AI. And that puts almost all of us far from opportunity and participation in contestability. Same thing for accountability or explainability. That's all beyond the capacity of most of us, and importantly, beyond the capacity of ordinary citizens. And so one would like, in all of these presentations, one would like more and more human control of the AI systems, and yet what it calls upon is a degree of expertise that judges don't have, that most lawyers don't have, and certainly philosophers don't have, and then ordinary citizens as well. So how do we get contestability? Thank you.
Thank you for the question. So who would like to start? I think Lehte was first to address them.
Yes, I think this question was for me addressed. It's not easy, you know. I think it is a problem. So therefore, we as lawyers maybe need to also understand better or work more closely with those who are writing those codes and who are the creators of these, first creators of these algorithms. But the problem is that if we talk about artificial intelligence, it recreates it. So we don't actually know, even the one who created the first code does not know what the artificial intelligence did in the middle, because we will lose the track. It's like cancer going on its own way.
Mm. Thank you. Professor Cayón, would you like to respond?
Just to say that contestability, I think, should be embedded in all along the process, all along the algorithm life cycle, from the design to the testing of the results. It's quite difficult, but it should be so, I think. And I think the process of contestability and the process of design, development, deployment, and testing of the systems should be a process liderated by lawyers, not by technologists, of course. by lawyers, because we know the values, the principles, the standards, the aims that we want to reach. Well, it's a very simple answer. I'm sorry, but that's what I think at this moment.
Thank you. Professor Ernits would also like to comment on that, yeah?
Thank you. This is a really good question. I would like to draw a parallel because we have a practical case in Estonia. And this is a digital election. I mean, electoral process is transparent. It's designed to function that everybody understands how it works. If we now have this digital election with ID card at home, at laptop, no one in this room, perhaps someone, okay, but most of us in this room do not understand how it works. And we do trust the specialists who confirm us that it's proper. But we don't know, really. And this is accepted by the society. But I would even say that perhaps it is not that complicated in case of AI assistance in the courts. Perhaps we don't need the contestability in the whole, in the complete sense, because what can this AI assistant deliver? A draft judgment. But I, as a judge, write the judgments myself. So I think I will be able to control whether this judgment is in accordance with the law and whether these facts in this draft judgment are the correct facts. Perhaps it's enough. I don't know. Just as an idea. Thank you.
Professor Torchia, perhaps would you like to respond to Professor Postemas' question?
Thank you. If I may, just a few thoughts on that. Of course, that's one of the central questions of legality of algorithmic administration. But as been already said, the administration often takes very technical decisions, and those technical decisions cannot be contested by any citizen. You need experts, for instance, when you have infrastructure decisions or decision on industrial plants. So we need the experts. The real problem here is that even the experts do not understand what happens when you have machine learning algorithm or artificial intelligence, because the system has some degree of autonomy. You don't really know. Nobody actually really knows what's going on. So that means I think that probably recurring to sandboxes, to some regulatory space when you can have experiment on what's going on and what are the consequences is the best tool we have. It's not perfect, but I don't think we have much more than that.
Thank you. So please, more questions. Yes, Professor Latorre.
All right. Now, when I listen the word expert when dealing with law and legal decision, I get worried. A judge is not an expert traditionally. In principle, you know, for instance, that you might know, today I spoke about Roman law. You know that in Roman law, judges were not lawyers. Lawyers were consultants. Even advocates were not lawyers. Cicero was not a lawyer. Lawyers were taken from the educated people, cultivated people. And you shouldn't forget that we have in the Western tradition, the liberal tradition, the honorable institution of the jury. And the jury, there are no experts by definition. I don't know whether you know this wonderful film by Sidney Lumet, 12 Angry Men. I think this would be very important for judges to look at this film at least once per week. Why the judgment is not for experts? It's not the same to decide whether, I don't know, this watch works or not. Of course, when it does not work, I go to the expert, to arrange my clock. But if we should decide about some people are guilty, or we should decide whether something is wrong or not wrong in the society, we have to decide this in principle, all of us. And this is for a very simple reason. I don't know whether you have ever read Protagoras by Plato. If you haven't, I would recommend you to read this wonderful dialogue. You know, in the Protagoras by Plato, there is the so-called myth of Zeus, the myth of Zeus, the myth of God, we could say. Now, in order to explain the myth of Zeus, I gave you an example. I invite you to have dinner to my home in Spain, in Valencia. I prepare a beautiful table, wonderful wine. I have good wines. Perhaps even a Bordeaux, I don't know, 1996, okay? Because I want to honorate your presence. You are a good friend. You come. I'm very well dressed. Tie, Marinella, you know, Marinella is the best tie in Italy. And then I put also my silver forks, spoons, and so on. So I offer you wonderful dishes, a good pasta, and so on and so on. Then a wonderful cake, and okay, we have a wonderful conversation. And in the end, it's finished. Thank you. Goodbye. It was wonderful. And then I take you to the door of my home. And I give you your coat. And then, all of a sudden, I see that you are in your pockets, you have my silver spoons. You have taken my silver spoons. And I say to you, what are you doing? What is this? And then you reply, but you know, I'm not just. I don't have the sense of justice. I'm not an expert in justice. What should I do? I think I will knock you down, possibly. You know? Why? Because the sense of justice has been given to all of us by Zeus, by God. We go around, we have intercourse, the one with the other, presupposing that the other person has a sense of justice, that can understand what is wrong and bad. And our community as a democratic is based on this common assumption. So justice is not a matter of experts. Justice is, Kant would say, the commonest of the common senses. So please do not speak of expertise when discussing justice. I would be very grateful to you.
Thank you, Professor Latorre, for this story and lecture of justice. I feel now that Judge Ernits here feels a bit nervous already. So please, if you would like to respond to Professor Latorre's.
No, not nervous at all. But thank you, Massimo. Thank you very much for the invitation, first of all. I think there are 2 points. I think you are right, absolutely right, that sense of justice is in everyone. I don't want to contest that. However, the lawyers are trained in methods, how to apply rules, human-made rules, not God-made rules, human-made rules for the society, for other humans, to the relationships between the humans. So I think this sense of justice is not enough for that. It's not enough for that. It might be for very simple cases, but most of the cases in a practice are not simple. They are complicated, and that's why we need lawyers. The second point, I would argue that I think you used the substantive concept of justice. I would contest that. I would say that the concept of justice is we do better when we understand it in procedural sense. But this is another discussion. We can perhaps continue this. Exactly. Mike.
Anspruch auf Gerechtigkeit, auf
Richtigkeit, not Gerechtigkeit. Correctness, not justice.
No. Correctness become justice once you universalize, and in a decision you should universalize because your case should be applied to all other similar cases. So the Anspruch auf Gerechtigkeit also richtig auf Deutsch ist ein bisschen, zweideutig eigentlich. Also ist nicht so einfach. Richtigkeit und Gerechtigkeit sind zwei ähnliche Wörter. Die sind ziemlich nah als Wörter, also als Begriffe. Auf jeden Fall. Richtigkeit und Gerechtigkeit sind nah. Richtigkeit und Gerechtigkeit are very close.
Professor Latorre,
are very close.
Okay.
Und there is a claim. There is a claim to justice. Claim to justice. And since justice is not procedural justice in this sense, is substantive justice.
No. If I may,
yes,
just
please,
directly,
yes.
But despite of the quite close notion, these are two pair of shoes actually. The Richtigkeit or the correctness and justice. I would say that there is indeed claim for correctness, claim to correctness. And if we follow the procedure, then this procedure is just. This procedure is justice.
then you would never arrive to the Grauberg formula following this path. Anyway, this is philosophy of law. In any case, the important question is that law is not expertise, because you should justify your decision to acquire public. Law is something that should be understandable to the public, to the audience, even if it might be very technical in some parts. I agree with you. But in principle, law should be understandable to everyone. So forget about expertise. Being understandable to the citizen.
Okay.
The role of the judge.
Thank you, Professor Latorre and Professor Ernits for this discussion. We should move further with the questions, and I would like to ask if there are any questions in Zoom, because we have listeners in Zoom as well. If there is, please just intervene and ask the question. No, okay, there is a question. Yes, please.
Hello. I write my master's thesis on similar topics, so I have a question for you. What do you think, are there any areas or risks of AI that are not regulated by Artificial Intelligence Act, but should be regulated? What?
This question was addressed to whom? Or
I think to everyone.
To everyone?
Yeah.
Okay, so who would like to begin?
The Artificial Intelligence Act.
Thank you very much for this question. I actually hope that someone would ask something like this into this direction. As a matter of fact, I just wasn't so certain about it, so I actually left it out, but I want to bring it up now. When you noticed, there is only this recital 61, which, as I argued, would exclude the robot judge. But is this sufficient, actually? Is this sufficient? Because there is a catalogue of prohibitions, an explicit catalogue of prohibitions. And there is no such prohibition in this catalogue that would exclude the robot judge. So it would also be possible to argue that a robot judge is not a high-risk case. This is a low-risk case. There is no risk at all. I think this interpretation would be nonsense in the end. But this is possible. Grammatically, it's possible. So, yeah, that would be a case. The prohibition of the robot judge. Explicit prohibition of the robot judge.
Anybody else would like to respond? Lehte? No?
No, nothing more to say. It's true, it's true. Only in the recital 61 is clear that the artificial intelligence systems should assist judges and not replace it. In the articulate text, there is no provision like that. In the articulate, I think only use the word assist. Well, and in a contextual way, I think the proper interpretation is that that is an assisting tool, not a replacing, replacing judges. But it would have been clearer that that provision appeared in the articulate text.
Yeah.
Yes.
Yeah. Professor Torchia, would you like to comment on that as well?
Well, I want just to signal that actually the real problem with the AI Act is that it states rules for what we know. And technology has always innovation. If you compare the definition of artificial intelligence, the proposal of the regulation we had 3 years ago, and the definition of artificial intelligence it has now, it's completely different, because meanwhile, there was ChatGPT, and 3 years ago, nobody knew what ChatGPT was. So the real risk is that tomorrow we'll have a new solution, a new innovation, a new tool, and it will be not included in the rules of the Artificial Intelligence Act.
Thank you. Yes, please. Professor. We have time. Yeah, we have time. Yes, please. Yeah.
Oh, thank you. Thanks. Is this on yet? Yeah. So I've got a question for, I think, all of the panelists. And I guess the shortest version of the question is this. What is it you think that the dependence or invocation of AI in your various legal systems in Italy, in Spain, here in Estonia, what do you think it's helping us out with? What problems is it solving in these particular jurisdictions, right? Because everyone's spoken about AI as assisting, for example, judges, people deciding cases. Well, that's great. But as far as I know, certainly in my jurisdiction, that assistance already exists. The assistance is called judicial clerks. They write the first draft of judgments. They do a lot of research, and they're usually lots of our brightest undergraduate students on graduation are doing that already. I know that's a kind of carbon-based research tool rather than a silicon-based research tool, but it's already there, right? So I guess we could get rid of our students, our graduate students, doing that kind of thing in the apex courts and so on and so forth. In my own jurisdiction, there isn't a great deal of talk about use of AI within the substance of the law. There are various initiatives about making the bureaucracy more frictionless. So there's an online court system that the Master of the Rolls, who is the head of the civil division of the Court of Appeal in England and Wales, is pushing. But what he's pushing is a kind of online system for getting your case going, getting access to information, and so on and so forth. And it's just automated. There's no AI input. But besides that, here's one thing that people talk about the use of AI in my jurisdiction and invoking it in the legal system. Here's the problem that they think they solve. It might solve, and there's an undoubted problem. The problem is this. There's a massive problem with access to justice in my jurisdiction. But I know why that exists. Is it the same in your jurisdiction? Because I think my jurisdiction is unique in one way. I think the UK government was the only one that responded to the 2007-8 global financial crash by making the economic choice of austerity, by cutting public services, by reducing central government expenditure. It seems to me in the rest of the world, there was a Keynesian turn rather than a neoclassical turn. More investment, public investment to drive spending and to give the economy a kickstart. One feature of that choice, that economic choice, was the Legal Aid Sentencing and Provision of Offenders Act 2012, which reduced the legal aid budget in my jurisdiction massively. Right? So there was already an access to justice problem. It's even bigger now as a result of that economic choice. And people talk about use of AI as a solution to that problem. I get that. I can understand that. I don't think, well, I've got an easier, more parsimonious solution to the problem. Restore public spending in legal aid in my jurisdiction to the same level it was in 2012 and then we're going to reduce the access to justice. No need to start talking about AI or anything like that. Yeah, just restore the budget. What is it in your jurisdictions? What is it that's driving recourse to AI? Because I'm not really seeing it. I can see it in my own jurisdictions, but what's the big problem in Estonia that means that judges in Estonian courts need an AI system to help them out with? I know from colleagues in Italy there's a massive backlog of cases, civil law cases. There's not in my jurisdiction. You know, the courts are not overburdened in my jurisdiction, and the UK Supreme Court decides about 70 or 80 cases a year, and that's it. So there's not a log jam. So that was a really long way of putting the question, which is, what is it in your jurisdictions that's driving recourse to AI, do you think?
Mm-hmm. Thank you. So which jurisdiction we should start with? Estonian?
Local jurisdiction.
Local jurisdiction, yes. So,
Thank you.
I think Madis is the closest then, I guess, again.
Thank you very much. So what problems is AI solving actually, or supposed to solve? This is a very good question. I mean, we have this one single assistant now in use, which is preparing the texts of the audio recordings. This is technical, actually, a technical issue. I mean, judicial clerk is a very good assistant, but my judicial clerk gets sometimes flu and stays at home. Well, one could say that Salme doesn't work since the last update, right? It's sort of flu of the AI assistant, but we usually believe that the technical assistants work without they do not demand so much. They just work. They don't have emotions. They do the job. They don't get ill, etc. So I think what is expected is more effective administration, more effective judiciary, more effective courts, faster proceedings. I mean, it would be great if you bring the claim to the court in the morning and you get the judgment in the evening or next morning. It would be a dream for many, for the economy, for instance. You get a big claim, hundreds of pages, and next day you get the judgment. I mean, this would not be realistic because the other party has to respond, and it will take some time. But some sort of that we could increase, we could shorten the procedures in the future, perhaps. I think these are the desires, the hopes.
Estonian
yes.
representative of Estonian jurisdiction, please, if you have any.
Yes, I have
comments.
some wishes. So it's like a wish box. But what artificial intelligence could do for me, or help my life, to make my life easier, to reduce time spent on research, actually. And I think this is not only for professors or for lawyers, but it is also for administrators who need to do administrative decisions. So it could be used as a tool to help you to make more use of your time. So you can dedicate time to something else and reduce this. And the second thing I think that in future we can have is that we can ask him to assist us in legislation drafting, to look at the contradictions, to find out the contradictions with the current legislation and the future desires and etc. And now it is case by case and the knowledge-based research. Yeah, but I think artificial intelligence can be much faster and doing this kind of comparisons. Yeah, constitutional review, for example. We put the constitution to it, in front of it, and ask the new legislative act, put the legislative act there too, and ask, please, look up the contradictions with, how do you understand the contradiction with this, with the constitution? Sorry? But maybe these lawyers could do something else then. we can make it more automatic. Yeah. So and also to transpose the EU law to national regulations, legislation. Also, again, to compare it. What is our current law? We insert also the new directive to the system, and then it makes the comparison for us. Of course, we as lawyers, we need this critical review. We need to understand if the result is correct or not. So it's like studying mathematics. You first need to know how to calculate plus, and then you can start to use the computers or the calculators to do the job for you. I think it's the same thing with artificial intelligence now. You first need actually to know what would be the probable correct answer, and then you can let the artificial intelligence to do the work for you. Because you cannot automatically say that this result is correct. You need to have this capability to as we call the contestability, yes, and the accountability question. We need to be able to contest the result. Is it correct or not? But if we do not know how much is 2 + 2, we cannot know if the answer 5 is correct or not that the artificial intelligence gave us.
So lawyers going to need 2 degrees.
Yes.
IT engineering and then the law degree.
Yes.
Bullet.
In the future.
In the future, yes. But jurisdiction of Spain, please.
Well, if you ask me about the main problem of Spanish jurisdiction, I have no doubt. It's the unbearable delay of proceedings. I'm speaking not of months, but years of delay in many ordinary problems and disputes, basic disputes, very important for the ordinary people in his lives.
Just amount of cases in the courts, probably.
Yeah, amount of cases in the courts. No much judicial resources, material and personal resources. Yes, I think this is the main problem. What can do artificial intelligence for improving that situation? Well, I think it can do some things. Only in the administrative part, in the management of cases, has a lot of work to do. Artificial intelligence. Only applying, I think, only applying artificial intelligence in the administrative management of the cases, the delays would be shortened. Shortened? Yes. Yes. Or improved the situation. I think another problem, I think is a global problem, is the access to justice. Mm-hmm. I think not only in England and Wales, but I think it's everywhere. It's everywhere, and in Spain also. I think that artificial intelligence can also play an important role in this regard. it's not the subject today, but the use of artificial intelligence in the legal profession, I think, is improving that aspect of the problem. How? Doing legal information more accessible to the people, and having a preventive approach to the problems, and not an exposed approach to the problem. And finally, I think you can tell us more of than we can tell you, because I think England and Wales are at this moment making an important, a deep reform of the civil administration of justice, putting into service plenty of online services to monetary claims, to divorce cases, and to another civil matters. And perhaps you could tell us how it's working.
Mm. Okay.
Running, but it's not so much an AI initiative, just an automation of processes to make the bureaucracy work quicker.
Okay. I'm sorry to intervene, but we have
another
jurisdiction to respond to the Italian jurisdiction.
Sorry.
So please, Professor Torchia. Yes.
Yeah, very briefly. As far as I know, in Italy, we don't have any use of artificial intelligence in the justice system. We have digitization, meaning that briefs and appeals now are not written on paper, but we have an internet system, and the whole system is digitized, but the hearing, the discussion are completely done in person, and the judge is just, doing his traditional job. There is a beginning of use of artificial intelligence in legislative drafting, but it is just a beginning, so we don't know how it will develop. While artificial intelligence is largely used by the administration, for instance, to fight tax evasion and in health as well.
Okay, thank you. And we are exactly used our time. We are very precise in our second session. So thank you, all the panelists. I think it has been a very interesting and fruitful academic and also practical, I would say, discussion. So thank you.